My name is Dominic Maley. I'm a partner at McLaren's Lawyers, and I'll be talking today about the criminal law sentencing regime in New South Wales. Many people have heard of some terms associated with criminal law sentencing. People may have heard of a Section 10, or they may have heard of a suspended prison sentence. But as of the 24th of September 2018, the New South Wales criminal law sentencing regime was drastically overhauled. Suspended sentences, for example, have been done away with, and the regime has been put together to focus heavily on the good behaviour bond and the supervision bond program. To take you through the program, I have decided to separate sentences that involve no conviction versus sentences that involve a conviction. In practice, the fundamental concern of many people is that they do not receive a criminal record at the end of the day. Many people have not been to court before. This is their first time, and they've just been caught up in some form of charge that they wish never occurred, and they wish to not tarnish their reputation. The ways you can proceed to not have a conviction are twofold. Under the old sentencing regime, people would often hear of Section 10s. Section 10s were broken up into two parts. There was a Section 10(1)A, which is a complete dismissal of the charge, notwithstanding that the person pleads guilty or is found guilty. And there was a Section 10(1)B, which is no conviction recorded. Again, there's the dismissal, save for the person has to go and enter into a good behaviour bond. Section 10(1)As are still in existence, but a Section 10(1)B, so the good behaviour bond program, has been replaced by a conditional release order program. Conditional release orders themselves are broken up into two parts. So there's a conditional release order without a conviction, which is the equivalent of an old Section 10(1)B. There is also a form of conditional release order with a conviction, and that is the equivalent of what used to be known as the old Section 9 bond. So in summary, you have the Section 10(1)A, which is where you just have the matter dismissed, no conviction recorded, and you're free to proceed with your life as is. You have the conditional release order without conviction, which is in place of a Section 10(1)B bond. And then you have a conditional release order with a conviction, and that's in place of the old Section 9 bond system. From there, you have sentences that carry a conviction. So in addition to a CRO with a conviction, you also have a whole raft of other sentencing options which also carry convictions. You have a fine only, where if you are given a fine in a criminal matter, so not in a matter where it's a parking fine that you've challenged in court, but a criminal matter and you're issued with a fine, then that carries a conviction. You can also be given a Section 10(A), which is confusing because that is sometimes conflated in people's minds with a Section 10(1)A, but Section 10(A) is different. Section 10(A) is a conviction recorded with no further punishment, but you do have that conviction recorded. From there, you have what they call now a CCO, which is a community corrections order. A CCO is quite a broad ranged order, and that basically conflates the prior good behaviour bond system with the community service system, save that you also have a whole series of orders which can be imposed, including a curfew condition, imposing a specified curfew not exceeding 12 hours in any 24-hour period. You can have the community service work not exceeding 500 hours or a number of hours as is prescribed from time to time. You can have rehabilitation orders and the like. The final major sentencing option before we go into full-time custody is what is known as an ICO, which is an intensive correction order. ICOs are extremely broad in their application now. They don't exist, or they can't be applied for certain prescribed offences, and they can't be prescribed for domestic violence offences unless the court is satisfied that the victim is protected. An ICO is what people often conflate with the old home detention. It doesn't necessarily have to involve home detention, although home detention is often a condition. So you can have home detention under an ICO. You can have the electronic monitoring system, which is the ankle bracelet that people sometimes see. You can then have the curfew, and you can have community service not exceeding 750 hours or more if prescribed, and a series of other possible potential additional orders. One of those orders has to be imposed in addition to the standard orders under an ICO. From there, you do have full-time custody. Full-time custody is obviously a matter of last resort, and a court should consider, or must consider, all other alternatives before imposing a full-term custody sentence. If you require any further advice, this is obviously just a broad stroke approach to sentencing law, but it is hopefully useful to you. If you require any advice in relation to any criminal law matter, feel free to get in touch, and we can give you advice which is actually tailored to your specific scenario. Thank you.